Dan did a really good video the other day about self-defence and defending other people. And it was all on the back of a police disciplinary case involving armed police. So what can I bring to the party? Well, back in olden days, I actually used to do seminars for the armed police. So what I thought is I'd just share a little bit of that with you and perhaps explain what the issue is. Okay, so first of all, what is self-defence, defence of another? You are, of course, allowed to use force to defend yourself, but you're also allowed to use force to defend other people. And if that's your job, like police officers, then obviously this very often comes into play because you're there to protect the public. So, what is the test? Well, the test it's a two-part test. And for criminal purposes, it's part objective, part subjective. And what do we mean by that? Well, the first thing is, what did you honestly believe the threat was? What did you honestly believe the situation was? Okay? And that's purely subjective. It's your state of mind. Okay? So even if you are mistaken, it doesn't matter, so long as it's an honest belief. And then the second part of that test is objective. What would a reasonable person, thinking what you're currently thinking and assessing the situation, what would they think was a reasonable response? The phrase we use is reasonable, proportional, and necessary. That's not necessarily, that's not necessarily the same as minimum force. Reasonable force doesn't necessarily mean minimum force. And just as an aside, I like to go off at tangents. If you're defending somebody in your own home, we don't quite have stand your ground here officially, but it's always been that you are allowed to use force to protect your own home. And when it's defending against somebody who's in your property, to be unlawful, the force has to be grossly unreasonable. Not just unreasonable, grossly unreasonable. That was all on the back of all the Tony Martin stuff. But generally speaking, your response has to be reasonable. So what has changed? Well, that used to be the same test for civil law. Okay, so it was, you're honest even if mistaken belief. That's all we needed to assess. However, that changed. And for civil law, your belief has to be reasonable as well. So, it does allow for the possibility of mistake, but it has to be a reasonable mistake. It's like, oh, I misread the situation. The law does recognise that in a fast-moving, dynamic situation when you're scared, that obviously your reasoning skills, might not be 100% up to par. And one of the things I used to lecture a lot on was all these sort of what we call perceptual distortions in combat. People get this slow motion time. People's recollection goes out the window. I mean, there's all sorts of really fascinating case studies. There was one where all they could recall was that somebody was throwing beer cans at them during the gunfight. And this clearly never happened. And they were asked to describe the beer cans. And they said, they were sort of like, bronze-coloured beer cans. They said Federal on them. And they realised what that person was seeing was actually their own ejected shell cases flying past them. But they had processed that information and seen them as beer cans. So, that is understood. And people do make allowances for that. I mean, the general test for the court is, what did you do in the spur of the moment? Because that's the best evidence as to what you genuinely thought the situation was. So, if it's something you do instantly, then arguably that's proving your state of mind. But obviously for professionals, they are held to a slightly higher standard. But, what's unusual about this case is, for the purposes of the disciplinary proceedings, they've applied the civil standard. And they have said, no, your assessment and your belief had to be reasonable, not just honest. And obviously, the Police Federation and, armed police officers generally are sort of going, well, hang on a second, that's rather bearing in mind the consequences, we could lose our job, but that's arguably too high a standard. But that's what the issue is about. But like I said, this applies to everybody. So if you are attacked or you see somebody else being attacked, nobody's expecting you to do a full risk assessment and, verify everything. It's like, right, in that spur of the moment, what do I need to do? Because obviously, there is an element of urgency there if somebody is under a serious threat. If somebody is just being threatened, then arguably you've got a little bit of time to think about it. And this is the same thing, I mean, police shootings are very rare in this country. You know, even police drawing their weapons is really, really rare. But when it does happen, obviously, it has very, very serious consequences. But again, just thought that might be interesting to see what, you know, of course, the fuss is about, but also to give you some guidance yourself if you're ever in that unfortunate situation where you have to defend somebody. And, keep forgetting this, but the duck reminds me. Thank you, Lord Loverduck. If you found that useful or interesting, please consider clicking the like button, and also please consider subscribing.